It went off.
No, it went and now it's back. He has to type the message.
Yeah.
A very good afternoon to our viewers and welcome to the 1873 TV, Your Vision, Your Power. My name is Tinashe Mbasiri. This afternoon on the 1873 TV, we bring you yet another insightful and informative show on Shabhani Mashaba Mines SMM Special Part 16, where we continue looking at the parliamentary transcript that entails the questions and answers that we asked in Parliament. We continue looking at what then Minister of Justice and Legal Parliamentary Affairs, Honorable Patrick Chinamasa, stated pertaining to the questions that were asked regarding the State Indebted Companies Act, whether it was constitutional and whether it did not breach the constitutional provision on property rights. And we also got to understand what the minister also stated to the questions that were asked by other parliamentarians regarding the involvement of the executives in administration of private companies. The main purpose of this conversation is for us to better understand the facts behind Shabhani Mashaba Mines, and having understood those facts, we can be better informed individuals as to some of the issues that actually affect us on a daily basis, especially when it comes to corporates. Joining me this afternoon on the discussion is Mr. Mutumwa Ziwamawere. Mr. Mawere, a very good afternoon and welcome to the 1873 TV.
Good afternoon, and thanks for inviting me.
And we also happen to be joined by Advocate Jake Matiza, who happens to be on our telephone line and is based in Port Elizabeth in South Africa. Mr. Matiza, a very good afternoon and welcome to the 1873 TV.
Afternoon, Tinashe, and afternoon to all the 1873 network listeners.
And just for the benefit of those who are tuned in on Zimbabwe Today Live, for you to also access the documents that we're looking at today, it's the same document that we were looking at yesterday. All we have to do is just go to the 1873 TV Facebook page, where this document is available for your convenience to also go through with us. So, Mr. Mawere, if we are to pick up from where we left yesterday, we found quite a lot of interesting aspects pertaining to the questions that were posed to the minister then, the Minister of Justice then, as far as the constitutionality of the Recon Act is concerned, and more importantly, even the involvement of the executive in the administration of private companies.
Yeah, I think yesterday we left at the specification
of company. That's where we left off.
Companies. Yes. And Mr. Matiza, are you there?
Yes.
Which is number 4, where Mr. Sikala asked the Minister of Justice, Legal and Parliamentary Affairs to clarify the steps involved in the specification of companies, explaining how companies are placed under state-appointed administrators.
Number 1, it's Mr. Sikala.
You got it?
On page 3 of the document, the second column, if you scroll down, you can see where it says Mr. Chinamasa and some text is underlined, and just below that, you see where it says specification of companies.
Page 5. Yes. Specification of companies. Yes, I'm there.
That's right. So you go to the next page, which is 964. You got it?
On 4, the Honorable Sikala was asking the minister how is the company's what are the steps involved in the specification of companies?
That's right.
That's correct.
Yes. And then there is the response from the minister.
Yeah. Okay, now we are at the response by the minister. Minister says individual persons and companies are specified by the Minister of Justice in terms of Part 3 of the Prevention of Corruption Act on reasonable ground of suspicion that any person has by theft, fraud, and other unlawful means caused the misappropriation of funds.
Yes, am I right, sir?
You got it.
Brew, right?
Hello?
Mm-hmm.
You got it?
No, I'm still here.
Yeah. Then first,
Ground floor.
it's caused the misappropriation of funds. So either you stolen funds, you committed fraud, and any other unlawful means. In the case of SMM, in the case of the facts of SMM in Zimbabwe, what would constitute misappropriation of funds? It would ordinarily be things that happen within the jurisdiction of Zimbabwe. Do we agree there?
Yes.
Would the cession or the alleged cession diversion of funds fall within the ambit of the Prevention of Corruption Act? Would it fall within that, within the ambit of that act?
Come again?
I said the cession or alleged cession or the alleged diversion of funds in South Africa, would it fall within the ambit of the Prevention of Corruption Act?
But it has happened outside Zimbabwe. That's the first thing.
Yeah.
So on what basis will it then fall within the prescripts of the Prevention of Corruption Act?
So you'd agree that the act only applies to facts and circumstances that occur within the jurisdiction of Zimbabwe?
Yes. Because how can it then on which legal basis would it rest?
Okay. So no.
Because if you're saying that the facts, there's a jurisdiction issue. The facts arose in South Africa and the transaction
No,
is
we're
in
just
South Africa.
assuming that.
So how can then transaction be in South Africa be governed by a law of Zimbabwe? That's where my question is.
Now let's go to you. You are a citizen by birth of Zimbabwe,
Yes.
and you are located. You are now living outside the boundaries of Zimbabwe.
Mhm.
If the Minister of Justice in Zimbabwe were to specify you in terms of the Prevention of Corruption Act,
Mhm.
what would be your reaction?
What would be my
Reaction.
I'm Zimbabwean by birth. I'm based in South Africa, and then I'm specified
Yeah, you may have
based
shares.
on the Corruption Act.
Yeah, you may have
specified
shares
in
in it-
Zimbabwe, and I'm not resident there.
Yeah.
I would maybe appeal against it.
No, even just
On
the
what basis?
or even the
Because I'm not
construction.
resident in Zimbabwe. The transaction did not take place in that country. So
How would the Zimbabwean law
yes,
be exported to apply to you and to limit your rights
unless they've then applied for an extradition of some sort. But in its, without that, then it will be of no effect. It's void.
It's void. But the fact that a minister in Zimbabwe, knowing that you are non-resident, and still pursues that action, applies the law to a person who is incapable of committing that offense, because you can't steal. If you stole money in Zimbabwe, you have to present yourself in Zimbabwe. If you committed fraud,
and I'm not resident there, yes.
Yeah, if you committed fraud, that fraud then would be something that can only occur within the jurisdiction of Zimbabwe.
The borders of Zimbabwe, yes.
Yeah. If any other unlawful means, that unlawful means can only apply within the territory of Zimbabwe.
Okay. Sorry, can I just attend to something quickly? I'll be back.
Okay. So, do you agree there?
Yes, I think I totally agree with what Mr. Matiza had also stated, because honestly, being a resident in South Africa, then the minister issues, specifies me as an individual. It's something that I would find pretty absurd, to be honest. Finding that the Zimbabwean law would actually apply to a South African resident.
Okay. Then we have Section 6 of that Act is instructive in this regard. A notice of specification is published in the Gazette in terms of Section 6.2, Section 6, subsection 2, and then an investigator is appointed to investigate such person or a company in terms of Section 7 of that Act. Section 8 to 11 provide in detail the work of the investigator. A specified person has a right of appeal against such specification to the minister. In terms of Section 12, it is misleading for the honorable member to say that the specified persons or companies are placed under the state-appointed administrators. The administrators referred to are appointed by the Minister of Justice in terms of Section 5 of the Reconstruction Act to administer state-indebted insolvent companies. I would respectively refer Honorable Scala to the provisions of this Act in order to familiarize himself and get in-depth understanding thereof. Then there is a question by Honorable Scala, but that is not in relation to SMM, but in relation to international trade. Then we come to okay, we come to page 9. I think 968.
968. That would be on the document. It would be page 5 of the 18 pages.
Yeah. It says Mr. Scala asked the Minister of State for Indigenization and Empowerment to define the ministry's policy on indigenization, particularly in light of the recent takeover of assets owned by black and individuals through state instruments, like what happened to Mutumwa Mawere, James Makamba, and Jeffrey Muzimbi. the Minister of Justice, Legal and Parliamentary Affairs. Mr. Speaker, on behalf of the Minister of Indigenization and Empowerment, I will read his answer. I would like to draw attention to the House that there are two aspects to the answer. The first aspect is directed to the Minister of Indigenization, and the other one needs to be addressed by my ministry. Mr. Speaker, let me begin by advising the Honorable Scholar that the revised policy on indigenization of the economy is not only my ministry's policy, but rather indeed government policy, which was approved in October 2004. The policy objective of the government for the indigenization of the economy is to deliberately create economic opportunities for the historically disadvantaged black people in order to promote national economic well-being and guarantee political and social stability by increasing their ownership of productive assets in the economy, creating a conducive economic environment that will allow indigenous participation, developing a competitive private sector that spearheads economic growth and development, and a self-sustaining economy. Government has therefore decided that at least 50% enterprise shareholding in all sectors be held by indigenous people. Mr. Speaker, I would like to emphasize that government's indigenization policy is being implemented within the confines of the law of Zimbabwe and should not be abused as a front for illegal and corrupt activities by indigenous players. Finally, I would like to request the honorable member to refer the second aspect of the question relating to the alleged takeover of assets owned by black individuals through state instruments to the Minister of Justice, Legal and Parliamentary Affairs. The indigenization policy of the government has been clear since its inception in the early 1990s, whose main thrust is to economically empower the black indigenous Zimbabweans. It is not government's policy to take over the assets of anybody by means other than by lawful means. I am not privy to take over of the assets, the takeover of the assets of the referred to persons. However, it is incorrect for Honorable Scholar to merely assert or suggest that the assets of Mr. Mawere were taken over without making reference to the laws providing for such takeovers. Mr. Mawere's case is different from the other alleged two, that it is in terms of the Reconstruction of State Indebted Companies Act, and there are pending cases before the courts in terms of that act. The argument of the indigenization policy being advanced by the honorable member is tantamount to saying the laws of Zimbabwe should not apply to black indigenous Zimbabweans. Appointment of Mr. Afaras Gwarazimba, Mr. Scala, as the Minister of State Enterprises, Anti-Monopolies and Anti-Corruption, to inform the August House on the process used in the appointment of Mr. Gwarazimba as the administrator of SMMH, to furnish this House with Mr. Afaras Gwarazimba's remuneration package, to confirm if SMMH funds were used to finance the Cholocho gathering in late 2004. The Minister of Justice, Legal and Parliamentary Affairs, Mr. Chinamasa, responded as follows. Mr. Speaker, the question was incorrectly directed to the Minister of State Enterprises, Anti-Monopolies and anti-corruption. So when it was brought to my attention that it should have been directed to me, I then prepared this answer. The process used in the appointment of Mr. Afaras Gwaradzimba as the administrator of SMM H. Answer. Mr. Gwaradzimba was appointed in terms of Section 5.1 of the Presidential Powers Temporary Measures Reconstruction of State Indebted Insolvent Companies Regulation 2004, published in Statutory Instrument 187 of 2004, now superseded by the Reconstruction of State Indebted Insolvent Companies Act. So it is clear from the minister, as we have discussed before, that actually there was no law.
Yes.
There were regulations passed, and they were contained in a statutory instrument. So Parliament was not involved in the affairs of SMM. What is the significance of this? It means this is the executive passing the law, member of the executive.
And earlier, yesterday, we learned that he had actually stated there was no involvement of the executive in the affairs of private companies, especially when it came to the Reconstruction Act.
Yeah. In this case, he is essentially confirming that, yes, indeed,
The executive was...
this was done outside the four corners of constitutionalism. Because constitutionalism limits the powers of any minister to behave in the manner in which he has behaved. In this case, he is arguing that SMM was a national asset, and accordingly, SMM was a state, which is what you call this a key point, was a key point, which is a national key point, which is a national asset, deserving the attention of the president, that the collapse of SMM would have been so catastrophic to allow the collapse to take the normal course. And therefore the government was compelled to take preemptive measures, which it says it did. So we have that confirmation. And then he then proceeds. The remuneration package of Mr. Afaras M. Gwaradzimba, the remuneration package of the administrator is in terms of Section 30 of the Reconstruction of State Indebted Insolvent Companies Act, which provides that he shall be paid by reference to paragraph 3 of the 5th table of fees contained in the 7th schedule of the Companies Act. And such remuneration shall be taxed by the master of the High Court. Here you have the master of the High Court, who is not involved at all in the appointment of this creature of statute.
And what baffles me, Mr. Mawere, especially even the aspect of tax itself, should it not be the Zimbabwe Revenue Authority that taxes one's income?
No, Master of the High Court should tax it because if you are a liquidator appointed in terms of the Insolvency Act, the master is vested with the control of the administration of that estate.
Okay.
Yeah. So something is something that is ordinary. But in this case, you have somebody who is appointed outside
the four corners
of the powers of the master of the High Court. Then now, the person so created outside the sphere of the master's influence, that person now becomes subject to the control of the master, only in terms of taxation of fees. So that is in essence, what is being said. Thus, the package is computed at 6% of the gross proceeds or gross turnover of the company and every associate and subsidiary thereof. Do you see the input of that?
Yes.
Yeah.
The whole group of companies.
Even companies that fall outside
SMM.
SMM. So it's saying if you have including the income of your nieces, your nephews, your children, if you committed murder, the scope of that offense goes beyond the individual responsibility. It affects everybody in your family.
I think it takes us back to what Honorable Sikala actually asked in the first question as to whether the State Indebted Insolvency Act breaches the constitutional provision on property rights. And lately on the 1873 FM, Mr. Mawere, we've been having conversations, especially when it comes to property, the aspect that labor as well as time that you combine together and produce they produce a result, and that result is property.
Yeah.
Then somebody is coming to actually reap where they have not sown.
Yeah.
They're coming to reap one's sweat and blood. Clearly this breaches the constitutional provision on property rights.
But also it goes beyond that. Liability is prescribed to the party that committed that transgression.
Yes.
I can't go beyond, because each company is and ought to be a juristic person.
Yes.
So it must be circumscribed. But in this case, this law allows the administrator to go and collect even from companies that fall outside the scope of the reconstruction legislation. In this case, they have incorporated every other company that could be associated and said, you all now fall under this person. I think literally some problem with Zimbabwe today.
Mm-hmm. Seems to have like frozen.
Yeah. Okay. So that is the administrator is the principal of a firm of chartered accountants, AMG Global, and such fees are payable to the firm. So imagine you make your turnover is 1 billion. The import of this is at 6%, not after tax.
Before tax. This is gross.
This is like a royalty, like tax on turnover goes to you. When you look at it post-tax, how much is that?
Because we're looking at, this is assuming 1 billion revenue.
Yeah.
6% of 1 billion.
Yeah.
We're talking of a figure that's over 60. We're talking about 60 million.
And the company is sick. Now I'm getting 6% of turnover. Which money ought to go to the workers? Which money ought to go to running the operations of the company? That money is skimmed away. Even for companies that are not part of
this whole
scheme. Those companies now fall within the ambit of this draconian law. And Minister of Justice sees no evil, hears no evil. Whether SMM Holdings funds were used to finance the Cholocho gathering in late 2004. But this, you know, that the allegation was Chinamasa was part of
The Cholocho.
the Cholocho. He was destined to become the national chairman of the reconstructed ZANU-PF. So this could have been part of the reconstruction scheme, so that the finance, if Gwarazimba gets 6%, then it followed that the loot will be then shared. And Chinamasa would have very little resistance to anyone who would say it's okay to give Gwarazimba 6%. He would not say, why don't we find other administrators? And how he managed to secure Gwarazimba, which address did he go to? Nobody knows. Are you sure it's a posting? There's nothing. Then I am not privy to what the honorable member is asking, and I deny that any SMMH funds have been applied by the administrator to purposes for which they were not intended. Again, how would he know? How would he deny something that the administrator would have to bring his own books and confirm exactly how those funds
Are being
were
utilized.
deployed?
Yes.
In this case, you find the minister protecting, no interest at all in establishing what the facts are and what the facts should have been. There is very little resistance by the minister. And the question is, why would a minister of justice be averse or even allergic to the truth? In this case, the minister obviously was irritated by Honorable Scala's line of inquiry. And all he was now doing was to silence Honorable Scala. Then Mr. Scala follows. Mr. Speaker, I think the minister knows that when the SMM was started, he said it was on the strategic interests of the nation. Mr. Speaker, that also includes the issue of being transparent and accountable. There are facts, Mr. Speaker, that some funds were used for political campaigns last year by certain ZANU-PF factions, and these monies were driven from SMM. Could he clarify whether a certain faction of ZANU-PF took the money? And Mr. Speaker, withdraw the word faction. You are advised to withdraw the term faction. If need be, mention users. Otherwise, you want the minister to confirm whether some money was diverted. Again, we still don't have. Okay. Mr. Sikala, I want to get clarification whether some politicians did not dig their hands into the coffers of SMMH. since it was taken over by government, and also whether the minister is free and not scared that investigations to be put in place to see how SMM funds were used since the takeover of the company by the government. Mr. Speaker, you are not going to win, Honorable Scala. Faction is going to remain on the record. I'm saying withdraw that way, then you can continue. I withdraw. There is no truth whatsoever that any political person or political force dipped hands into the funds of SMMH. I understand the motivation behind the question is to mudsling than to secure a truthful response. Mr. Speaker, say, I do not think so, Mr. Speaker. I have evidence to this effect. My understanding is that the former Minister of Mines and Energy, Mr. July Moyo, is said that he's going to make sure that SMMH refused to fund some politicians who approached them to fund their political project. There is no substance in that question. Indebtedness of SMM Holdings. Mr. Scala asked the Minister of State Enterprises, anti-monopolies, white monopoly capital, and anti-corruption. It's a minister of anti, to enlighten this House on the indebtedness of SMMH since the appointment of an administrator and to provide a breakdown of application of the funds. The Minister of Justice, Legal and Parliamentary Affairs, Minister Shinamasa, as I've already alluded to in my earlier responses, as at 6 September 2004, when I issued the reconstruction order, SMM Holdings was indebted to the state in the sum of Zimbabwean dollars 15 billion between that date and April 2005. Now he's saying when he took over, there were new funds that were extended to a company under the control of the administrator. The government advanced a total of 510 billion. This gives a total of 616.5 billion owed to the state by SMMH and the reconstruction scheme. He's saying the company, under the control of the administrator, was given this gravy train full of 510 billion, which was in addition to 115 billion. That was at the time the control of the company was changed. Do you understand it?
Yes.
This gives a total, we are merely seeking to convert what we are owed into equity in SMMH. There is no other creditor who is owed this much. In fact, we have had to pay off other creditors in order to allow suppliers to continue supplying SMMH. So we are basically now the sole creditor of SMMH. And can you see where he's lying?
Yes.
Yeah? The same person says there is no other creditor owed this much.
And now he goes on to say we are the sole creditor. In the same statement.
Yeah.
He contradicts himself.
He contradicts himself. And he doesn't even know that he's contradicting himself. The administrator, not the board would have known what the company was owing
Yes.
to its creditors.
Yes.
Now you have a person who is imposed on the company, who is now supposed to know the indebtedness of the company before he was even born, before his powers became relevant. The administrator has estimated that the company might need further government funding in the sum of 85 billion to return to viability status. Thus, the total estimated indebtedness stands at 825 billion, including interest estimated at 120 billion by 30 June 2005. They take over the company, then they put new fuel,
Yes.
and they say it's your account.
The absurdity.
And we are going to convert it into shares so that you dilute your shares. Then you have no right to ask, but where did this money go to?
Yes.
Which is what Sikala was asking. Do you get an answer there?
You don't get an answer at all.
There is nothing. They said government funding has been applied as follows. Indebtedness as at 6 September 2004. It means if you are indebted, why would you pay?
You wouldn't pay.
Yeah. So why would you charge?
You wouldn't charge.
Yeah. Funding between 6 September and 30 June 2005, 510 billion. What was the money used for? No explanation. Estimated funding required to take us to 30 June 2005, 88.5 billion. Estimated interest to end of June, 120 billion. To allow for electricity to be reconnected, we paid ZESA and other creditors as at September 2004, 8.5 billion. We paid. We paid other creditors 64 billion. Now the minister is part of the company.
He's now involved in the finance department of this.
He now has personal knowledge, and now he's the minister for SMM, where he is now closed with all the information required by anyone representing the company. It is important to note that the administrator has done tremendous work to turn around the fortunes of the company with the necessary government funding outlined above. Where, in 2017, where is the company?
It's gone down the drain. So
This
down
was
the
a
east.
company which had ceased to operate, which was jeopardizing the employment of at least 5,000 workers at SMMH, which was also jeopardizing the viability of Shabhani itself. The whole Shabhani community rotates around SMMH. So government had to intervene in the national interest in order to rescue the company, in order to ensure that the company continues to be a leading foreign exchange in our economy. Mr. Mazimuri, due to the fact that SMMH was a private company, what was the interest of government in funding a privately owned organization to the tune of 115 billion? How was government funding the operations? Where were there due diligence reports which were produced by this organization so that the government will now make a decision to fund it? Mr. Shinamasa, I thought the honorable member had been listening. I said, and I gave reasons why government had to intervene in a supposedly private company.
Yeah, you actually realize that the command economy did not start recently with command agriculture. This is actually the blueprint of command economy.
But the way he is talking to the honorable member, have you been listening? If you have been listening, you would have known that he never said anything. Why would a private company attract the attention of a government?
Of a government. Why would
Minister.
government fund
Why would
the
you
operations
be
of a private company?
possessed with this information? How did this information come to your possession? We don't know. But this minister, for some reason, he seems to be well equipped with all the information that his ministry should be begging to say, Minister, but I thought you were our minister. All of a sudden, you now seem to be the minister of what? SMM.
SMM.
Huh? What has happened for you now to divorce yourself from what you are appointed to do?
Meddling in the affairs of
Because
private.
of its critical role in our economy. It is the producer of asbestos. And we are very key world producer of asbestos. It earns foreign currency and also it employed 5,000 workers. There's the Shabhani community basically rotates around these mines. Again, the mine still has a life of 25 to 30 years. So, at current production level. But if the mine is closed, why would it have current?
It wouldn't. That's a very interesting question. To think of it, what the minister had stated, that the company had ceased operations.
Yeah.
It had totally come to a halt. But here he's stating that there is current production taking place.
So a company that has ceased production, it means simply it cannot attract any other investment. That's so we can leave it there so that we have what? We have a starting point for tomorrow.
To the viewers out there who tuned in today on the 1873 TV as well as Zimbabwe Today, as we are having this conversation, your comments, your questions, your remarks, they are very much welcome. We encourage you to participate in these conversations as they are all about enabling us as individuals to build communities of shared interests in matters that matter, in issues that matter. And what I have also come to learn as an individual, even from the conversations that I'm having with other individuals within my circle, it is important for us as individuals to invest in literacy, corporate literacy, power literacy, just to mention a few, even leadership literacy. It's fundamental to be spending time on such conversations that can enable us to build these societies that are progressive, that are inclusive, that are also prosperous. Mr. Mawere, thank you so much for joining us this afternoon as we were going through this parliamentary question and answer transcript for us to be better informed pertaining the facts around Shabhani Mashaba mines. To the viewers out there, please stay logged onto the 1873 TV as between 6 p.m. and 7 p.m. we'll be bringing you the 1873 Mentees Circle as we continue looking at building communities of shared interests. Tinashe Mpasiri is my name. Hope that you join us again tomorrow afternoon, the same time as we continue looking at this transcript. Goodbye for now.